Hey everyone in business law, I thought I'd put up a quick video on Chapter 11, and it can be a bit quick because it's really about the statute of frauds and when contracts have to be in writing. And I know many of you probably came into this class when you thought, all right, it's business law, and a big part of business law is going to be about contracts. When is there a forcible, a binding agreement, and when can damages be sought if there's a breach? Most people probably came in with the conception that, well, contracts have to be in writing. That's because they sound like they're so formal and because they're so important. Hopefully, you've already learned that most contracts do not have to be in writing to be enforceable. In fact, those that do have to be in writing to be enforceable are often executed outside the realm of a writing. And we don't care if the parties comply and do the work and supply the goods and exchange the funds. Everybody's happy and the law doesn't care. The law won't undo a completed, executed contract simply because it was failed to be put in a written form and it was supposed to be. So when we think about the statute of frauds, the requirement that that kind of contract has to be in writing, we're only thinking about it if it's in its executory stage, either one or both of the parties have yet to perform. So which contracts have to be in writing? Well, back before even the colonies really existed as the United States, before the Revolution, we had something out of Great Britain called the Statute of Frauds. We now have it in the United States. Every state in the unions adopted it. In most states have adopted either exactly or very closely the what we call the UCC, the Uniform Commercial Code, and that embodies the Statute of Frauds. The Statute of Frauds says, hey, sometimes contracts, because of their very nature, we don't want them to be argued to exist because it's ripe for fraudulent accusations. It's just fraud. It's just a lie. It doesn't exist. So we want people to show their true intent to be bound by reducing it to writing. Book really does a nice job on this. You don't need this video, but sometimes it's just nice to hear kind of a summary. And some people have asked, hey, Chapter 11, I'd like to see a video on it. On this, or in this area, the statute of frauds is summed up really nice by an acronym that I saw in a video by another professor. I'll give her credit. Her name's Jane Maller. I don't know her personally, but she puts up these nice educational videos about contracts, and I like the one she did about the statute of frauds. And she created this acronym called My Legs. If you can remember those letters, M for marriage. Contracts related to marriage have to be in writing to be enforceable. We're not talking about the agreement to actually marry because we know that's not enforceable. People can back out at the last minute. They get divorced the minute after. Those contracts, you can't say, well, you agreed to marry me, now you have to, or I'm going to sue you. We don't allow those kinds of lawsuits. We're not talking about that kind of marriage contracts. We're talking about those related to marriage, like a separation agreement after the marriage is ending. That's a form of contract law that's required to be in writing to be enforceable. The other very much related to it, prenuptial agreements. We're going to get married. We're worried about where our assets are going to go upon either death or marriage. That contract has to be in writing under the statute of frauds to be enforceable. So marriage. It's not going to come up too much in business law. But the one that will is the next one, My Legs. So it's a Y. What does the Y represent? Contracts for a year or more. So if I hire you permanently to work at my law office as a paralegal, that contract does not have to be in writing because in theory, you could die before 1 year transpires, or the law firm could go bankrupt or dissolve or close. But what if I hired you for 3 years? Would that contract have to be in writing to be enforceable? Yes. So you could walk away early, or I could fire you early and you wouldn't be able to sue, nor would I, unless we had reduced it to writing. So that's contracts for more than a year by their very terms. Be careful about that. It might be this huge project that there's no way that we could really kind of almost contemplate that this is going to take years for this big building project to occur. Does that have to be in writing under this rule? No, because we could fantasize or hypothesize the possibility that the contract to be completed in a year. What contract can't be completed in a year? If I hire you to play for the Red Sox for 2 years as a pitcher, that contract had to be in writing to be enforceable because by its very terms, it goes beyond a year. So it has to be by its very terms goes beyond a year. So what's next in the acronym for My Legs? L, and that stands for contracts related to the purchase and ownership of land, real estate. And this happens quite a bit. I used to do a little bit of real estate, not only law, but real estate in terms of brokerage. It comes up where a party will be orally discussing back and forth about the sale of the land. And it's happened one time to a good friend of mine. I was acting as his broker at the time. He's actually a lawyer too. But we had a tentative thing. We said, look, my client's willing to pay, I think it was $300,000 for this really nice house up in the Brookfields. And the seller broker said, we're going to be able to do that. That's great. Let's write it up. And then as I'm writing up, I'm faxing them. I don't hear from the other side for a day or two. I was getting a little concerned. I call them up. And so going to go, Jim, we got an offer even higher than that you gave us. And the sellers want more money. And this other couple came up more than $10,000. So my friend, in the heat of the moment, was so angry. He says, we got to sue him. I said, what's our problem? Under the statute of frauds, it has to be in writing to be enforceable. It may not be ethical, it may not be appropriate, because they did agree to us orally to sell us the house at 310. They got an offer for 320, and because we never reduced our written contract to writing, our agreement, there's nothing we can do about it. And that's a big thing in real estate. So contract for land. So it covered marriage, contracts by their terms are more than a year, contracts related to an interest in land. And the next one would be E. You're not going to have to worry about this too much in business law, but maybe a little bit. It's an executor's promise. So say my sister dies and I'm the executor of her estate, and somebody says, your sister was supposed to agree to do this with my business, and now I'm running her sort of affairs after she dies, and I agree to kind of go forward with what my sister apparently was negotiating to do. That agreement could be binding, but only if I reduce it to writing, because we recognize that executors are under sometimes not necessarily emotional stress, but lack of knowledge about all the different concerns and debts and obligations of the estate of a dead person, that for them to be bound, we want the executor to reduce it to writing. Or the other party reduce it to writing, the executor sign on and agree to it. The next one is good. This is the one that's the most important for you in business law. Goods over $500. So if I go into the Kubota, I think it's not Kubota, doesn't matter, whatever, the snowblower place that's not too far from my house, and I say to him, I said, boy, it's a really nice snowblower. He says, yeah, it's on sale. It's a great machine. And I say, you know what? I'm going to buy it. I'm going to be back tomorrow with the money. I'm going to buy it. Let's assume he takes my phone number down and types it into his phone, and I give him my name and address, because you're going to be back tomorrow. Yeah, I'll be back tomorrow at noon with the money. I'll be in cash, and it's for $1,200. Now, what if I don't come back tomorrow? Can they sue me for breach of contract? No, they can't. Why? Because it wasn't reduced to writing. Now, most of those kinds of situations come in. I'd have the $1,200 or the credit card. I'd pay for it. They'd give it to me, and there would never be a written contract. That's an executed contract. We don't care. The parties executed through performance. We don't need the written contract. It's over. What we do need is in the interim. Like, say I went in there and I said, yeah, I'd like to buy this, and I say I had the cash on me or the credit card. Yeah, I want to buy the $1,200. He goes, well, that's the floor model. I can't sell you that one, but I'll order one for you. I'm like, great. And then he comes out, and the next day he calls me up and says, Jim, we can't go forward on that. We got such a demand for him. We're starting to ask for $1,400 for him. Can you come up with another $200? I said, no, we have an agreement for $1,200. I'm going to sue you. Can I? Well, you can always sue, but am I going to lose? Yes, because it's a contract for a good. A good is a movable, identifiable object that the price is $500 or over. That's the biggest one that's going to haunt you in business. It happens all the time. I get this a lot where someone says they get an agreement. And I said, well, do you have a written contract? And we'll get to that in a second, what has to be in the written contract. And they said, no, it's all over the phone. It's not good enough. Well, how do we do these contractual things on the computer? There's a special electronic statute that basically says if you agree electronically to be bound by the terms, that's equivalent to a written contract. Because let's face it, especially now in the age of COVID, people do a lot of online shopping and buy things all the time for over $500. They're goods. And with that contract being enforceable, but yeah, because the electronic submission and request shows that's what we're trying to prove. Are people really intending to be bound to the agreement? We need proof of that. It can't be on a video, but the electronic statute says that the electronic request to be bound in the contract is enforceable. And the last one, suretyship. This will come up in business to some degree. If one party is going to become responsible for another party's debt to make good on it, because they're not really getting any real benefit from it, that would have to be in writing to be enforceable. So say I'm dealing with a company and I said, geez, I need so many ball bearings for you for my machine shop. And they say, well, Jim, we can't get steel into the place because we owe a bunch of money to the steel manufacturer and they're not willing to give us more product without us paying the previous bill. If I call them up and negotiate and says, what if I became a surety for them and promised to make good on their debt if they shouldn't pay it in the next 12 months, would you release some more steel to them? And they say, sure. They wouldn't be able to sue me on that promise unless we reduce it to writing. this seems fundamentally fair. I'm taking on somebody else's obligation. Suretyships, obligations, sometimes called co-signing. Those things that's why it's signing, because you're going to be agreeing to it in writing to be bound to another person's primary debt. And those are the big ones. Now, careful. There's a major exception to the rule. If one party has already paid or the other party's performed substantially a service in the contract hasn't been reduced to writing and it's one of those contracts that was required to be so, the court may either return the money to the other party or is going to enforce compliance with the contract as if there's a writing, because it's proof in the actions of the party to suggest there must have been a written contract. And careful, this is a major one. Let me read it to you again. If one has paid money or performed a service under an oral contract required to have been in writing under the statute of frauds, the money or value of services may be recovered even though the other party hasn't performed or paid or did their service. If one party has made part performance of an oral contract, it would be hurt if the contract were not enforced. Courts will allow enforcement of it. And it's based upon equitable principles, fundamental fairness, like promissory estoppel, which we talked about in previous chapters. Other than that, that's it in a nutshell. Now, what has to be in a writing? A lot of people think, well, the written contract has to be all. I got to admit, when I got out of law school, I didn't know much other than theory. I remember there was a store called Paulson's in downtown Worcester. It was a big stationery store before Staples and Office Max kind of wiped out companies like that. But you could buy letterhead and stationery. And I remember buying a box of legal paper. It's a size. I think it's 11.5 by 17. It's longer. Because I thought contracts had to be on legal paper. I thought wills would have to be on legal paper. I was wrong. Well, sometimes we like to do that to suggest we know what we're doing. It looks fancy. But the written contract can be really handwritten as long as there's enough what? We know from the offer and acceptance. Was it enough what? Definiteness to know what the parties are bound to. Now, careful here. This is a bit of a trick question, and I try not to trip you up too much on this. Do both parties have to sign? Most people say, yeah. You want to show you both be bound. What if you signed the contract, but I didn't? But I'm the one that wants it enforced. I'm trying to push for enforcement. Could you raise, but Corman, you didn't sign it, therefore the statute of frauds haven't been complied with? No, you can't. Because if I'm showing that I want to enforce it by suing, that's really the same equivalent of having me sign. So the trick question here, or the thing that confuses people, is we only need the signature of the party that's resisting enforcement. The party that's not resisting enforcement, we don't care if they sign, because there clearly isn't fraudulent as to them. They're showing their willingness to go forward with it. And by the way, when do they have to sign? Anytime right up into the eve of trial. So if somebody says, well, Corman, I'll sign it right now. Now you're bound, if that makes you more comfortable. So who has to sign the agreement? The party that's going to resist enforcement. Of course, you want both parties to sign it to show true assent by both. But it's kind of a trick question, because if I'm willing to go forward and I never sign the contract's still fully enforceable against the party that did sign it. It's kind of it in a nutshell, if you want to know that. Careful. So the note or memorandum, it also can be a series of notes or memorandums, as long as it's reduced to writing and signed by the party against whom enforcement is sought. It doesn't have to be any magic language. It doesn't have to have legalese, legal terminology in it. It just has to show definiteness, what the parties are going to be selling or doing or exchanging. Just has to have enough clarity to do that. Now, and you can reference other documents as reference in such and such a memo or such and such a term of agreement in another document. We do that all the time, but because it becomes incorporated by reference. Now, what's interesting about that is that sometimes people have side deals. They'll say, okay, I'm going to sell you the car for $5,000. And I agree, after a week you use it, I'm going to buy you 4 new tires for the Prius. I always use up my old Prius example. But we never wrote in the contract that I was going to deliver those 4 tires a week later. All of a sudden, now you sell the car, you're using it. A week goes by, you call me, hey, Corman, where are those tires? I said, I'm going to give me the tires. Now you sue me. Because there was a written agreement over the Prius, and the terms appeared to be complete, there was no reference to the 4 tires, you can't enforce those 4 tires, because that's called outside of it. That's an oral agreement, or parole. Parole means oral with this spelling. The parole evidence rule will bar parties to bring in anything else that modifies, alters, adds to, or changes the terms of the agreement, if the agreement appears to be what? Complete and unambiguous. Now, obviously, if the contract is in the party A will pay interest on this over the next 6 months, and party B will pay that, but we never put what the interest rate was. Well, now there's a gap. Now you can bring in oral evidence if because there's an ambiguity, there's a missing link, there's confusion. Then oral evidence come in. But if the contract appears, I can see what party A is supposed to be, I can see what party B is supposed to be, and now you're trying to bring in some side agreement that one party is supposed to do more or less. That is not going to work. And that's why I always tell people in the old days to be very careful. Back in the old days, when you bought a car from somebody, you have to pay sales tax on the registry of motor vehicles. It can be a pretty big hit. And I think they do it now at Kelly Blue Book value. I'm not sure, but back in the old days, you're buying a car for 10 grand, you'd say, hey, do you mind putting 2 grand on the bill of sale, which is your written agreement usually, right? Yeah, I'll put 2 grand down. And now all of a sudden the engine's blown on the car the next day. Now you're going to sue them for breach of warranty. Well, guess what you have in the car? You're suing for $10,000, right? You want your $10,000 back? The other side's going to say, oh, you paid me $2,000. And he goes, no, I paid him 10. That's a side. We have a side agreement. We're really paying 10. No, you're bound by what's in the writing. You can't have side agreements because the parole evidence rules bars out. Otherwise, we could always say the written agreement's not really our agreement. Kind of makes sense, right? But when there's gaps, ambiguities, or conflicts in the written contract, then oral testimony does need to come in as to what the true intent of the parties was. I think it makes pretty much good sense. I do like the parole evidence rule because I've actually been successful with it a few times as an attorney. Or I used to do landlord-tenant. I always remember landlord-tenant where the tenant would come in or the landlord would come in and say, but we also agreed to this. I'd object. And the judge said, what's your objection? I said, parole evidence rule, Your Honor. They have a complete written lease, and these outside agreements cannot be brought into court under this principle. It's a powerful tool. But it makes sense, right? Think about it. Otherwise, we can always say, oh, I was going to pay him $5,000 a year, but the real deal was I was going to pay him $1,000 a year. People just constantly be able to manipulate what was apparently their true intent on the written form. So whatever you put in a written form better be your true intent and better be complete. Don't leave things out. Otherwise, it's subject to debate about what you were actually intending. Hopefully, that's fairly short. I try to keep it short. Try to put up 12 tomorrow. Otherwise, be well. Don't be afraid to ask questions and reach out.